charges facing you are: count 1 is for Dr. Ken Tarus, Harun Karisa, Engineer Daniel Tare, Engineer Noah Ogano, Engineer Daniel Ochieng Muga, Engineer John Maura, James Murioki, Bernard Githui, Engineer Evelyn Pauline. Count 1, conspiracy to commit an offense of economic crime contrary to Section 47A3 as read with Section 48 of the Anti-Corruption and Economic Crime Act 2003. Particulars are: on diverse dates between 12 April 2017 and 12 June 2018 at Kenya Power and Lightning Company Limited within Nairobi County in the Republic of Kenya, jointly with others not before court, conspired to commit an offense of economic crime, namely carelessly failing to comply with procedures and guidelines relating to procurement, which led to the fraudulent payments of Kenya shillings 159,195,364.41 to companies that were unprocedurally pre-qualified for labor and transport services with tender number KP 1/2/2/PJT/1/16-17. Dr. Ken Tarus, true or false?
Not true, Your Honor.
Harun Karisa, true or false?
Not true, Your Honor.
Daniel Tare, true or false?
Not true, Your Honor.
Noah Ogano, true or false?
Not true, Your Honor.
Daniel Ochieng, true or false?
Dr. Ochieng?
Engineer Daniel Ochieng, true or false?
Go on. No appearance. Number 5.
Engineer John Maura, true or false?
Not true, Your Honor.
James Murioki, true or false?
Not true, Your Honor.
Bernard Muturi, true or false? Engineer Evelyn Pauline, true or false?
Not true.
Count 2 is for Dr. Ken Tarus. Willful failure to comply with the law relating to management of public funds contrary to Section 45(2)(b as read with Section 48 of the Anti-Corruption and Economic Crime Act No. 3 of 2003. Particulars are: on diverse dates between 12 April 2017 and 12 June 2018 at Kenya Power and Lightning Company Limited within Nairobi County in the Republic of Kenya, being the accounting officers whose function concerned the management of public property as the Managing Director and Chief Executive Officer of the Kenya Power and Lightning Company Limited, willfully failed to comply with Section 44 of the Public Procurement and Asset Disposal Act 2015 by approving a list of entities irregularly pre-qualified to render labor and transport service to void tender number KPL 1/2/0T/58/PJT/16-17. Dr. Ken Tarus, true or false?
Not true, Your Honor.
Count 3 is for Dr. Ken Tarus. Willful failure to comply with the law relating to management of public funds contrary to Section 45(2)(b as read with Section 48 of the Anti-Corruption and Economic Crime Act No. 3 of 2003. Particulars are: on diverse dates between 12 April 2017 and 12 June 2018 at Kenya Power and Lightning Company Limited within Nairobi County in the Republic of Kenya, being the accounting officers whose function concerned the management of public property as the Managing Director and Chief Executive Officer of the Kenya Power and Lightning Company Limited, willfully failed to comply with Section 68(1)(a) of the Public Finance Management Act 2012 by applying public funds under your care to an unlawful purpose, namely making fraudulent payments of a sum of Kenya shillings 159,195,364.41 to irregularly pre-qualified entities via tender number KPI/2/0T/58/PJT/16-17. Dr. Ken Tarus, true or false?
Not true, Your Honor.
Count 4 is for Bernard Muturi and Engineer Evelyn Pauline. Lawful failure to comply with the law relating to procurement, contrary to Section 45(2)(b, as tried with Section 48 of the Anti-Corruption and Economic Crime Act No. 3 of 2003. Particulars are: on the 31st May 2017, at Kenya Power and Lightning Company Limited within Nairobi County in the Republic of Kenya, being members of the Tender Opening Committee for the Labor and Transport Tender number KPI/9AA-2/0T/58/PJT/6-17, carelessly participated in a tender opening process without quorum in breach of the law relating to procedures and regulation relating to procurement. Bernard Muturi, true or false? Engineer Evelyn Pauline, true or false?
Not true.
Count 5, Engineer Daniel Tare, Engineer Noah Ogano, Engineer John Maora, James Murioki, and Bernard Muturi. Willful failure to comply with the law relating to procurement, contrary to Section 45(2)(b, as read with Section 48 of the Anti-Corruption and Economic Crime Act No. 3 of 2003. Particulars are: on diverse dates between 31st May 2017 and 18 September 2017, at Kenya Power and Lightning Company Limited within Nairobi County in the Republic of Kenya, being members in the Tender Evaluation Committee for the Labor and Transport Tender number KPI/9AA-2/0T/58/PJT/6-17, willfully failed to comply with Section 82 of the Public Procurement and Asset Disposal Act 2015 by failing to adhere to procedure and criteria set out in the tender document. Engineer Daniel Tare, true or false?
Not true, Your Honor.
Engineer Noah Ogano, true or false?
Not true, Your Honor.
Engineer John Maora, true or false?
Not true, Your Honor.
James Murioki, true or false?
Not true, Your Honor.
Bernard Muturi, true or false? Count 6 is for Dr. Ken Tarus, Engineer Harun Karisa, Engineer Daniel Tare, Engineer Daniel Ochie. Abuse of office contrary to Section 46 as read with Section 48(1) of the Anti-Corruption and Economic Crime Act No. 3 of 2003. Particulars are: on diverse dates between 12 April 2017 and 12 June 2018, at Kenya Power and Lightning Company Limited in Nairobi County within the Republic of Kenya, being the Managing Director, CEO, the Acting General Manager Finance, the General Manager Network Management, and the Acting General Manager Supply Chain, respectively, used their respective office to improperly confer a benefit of Kenya shillings 159,195,364.40 to entities which had been irregularly pre-qualified. Dr. Ken Tarus, true or false?
Not true, Your Honor.
Engineer Harun, true or false?
Not true, Your Honor.
Engineer Daniel, true or false?
Not true, Your Honor.
Engineer Daniel Ocheng, true or false?
Now I've entered pleas of not guilty in respect of accused 1, accused 2, accused 3, accused 4, accused 6, accused 7, and accused 9 as charged respectively.
Your Honor,
Yes.
I wish to make an application. I want to apply for warrants of arrest in respect to the 5th and 8th accused persons. Your Honor, we are unable to get them from the usual places where they can be found. So that's the reason we believe that they have gone hiding.
No representation?
Your Honor, we will respectively adopt the arguments made in 26.
You are appearing for?
I think the arguments will be slightly different because there's no representation in this matter. No. Okay.
Yes. We think, Your Honor, as officers of the court, we need to point out that, first of all, the proper application, I would imagine that would come from the prosecution, is for summons to issue against persons who are not before the court. It is not for warrants of arrest. Upon demonstration, Your Honor, that summons have been served on accused persons, and such persons have neglected to attend court, then the court may be persuaded to issue warrants against those persons. In the absence of such demonstration, Your Honor, we think as officers of the court that it is an abuse of court process to request for the arrest, detention, and arraignment of accused persons before this court when there really is no fault on their part. For the substantive arguments, Your Honor, we will fall back on the very able submissions by my learned colleagues in file number 26, which is before you. Your Honor, we respectfully suggest that your ruling on this matter again be deferred. Your Honor, to give us time to make substantive arguments on the bail application.
Yes.
Just like I had actually not preempted wrongly, in the other case, there seems to have been somebody who had been sent, and that is the 12th accused person. In this case, there is no one who has been sent on their behalf. The places where they usually work or where they live, we are not able to find them. Their phones are off. We have every reason to believe that they have gone hiding. So our application for warrants of arrest is justified. And I urge this honorable court to issue warrants of arrest. Your Honor, situations where we apply for summons is where we are not even sure. But here is a case where we are certain that the 5th and 8th accused persons are avoiding appearing either before the police or before this honorable court. I humbly ask this honorable court to issue the said warrant.
Yeah, I will still condense, I would wish to condense my ruling to one. So I'll still defer. Anything else?
Yeah, I believe now that we could make bail application number 26. I'll be brief.
Your Honor, we are ready for the application for bail. The prosecution has filed affidavits. And authorities that it seeks to support the application to oppose bail. Your Honor, to avoid or to save on time, the prosecution will have Mr. Njeru deal with the replying affidavit.
Yes.
In 26 of 2018, Mr. Muteti will deal with the points of law.
Mr. Njeru will?
Mr. Njeru will deal with the affidavit, the replying affidavit that we have filed. Mr. Muteti.
Replying affidavit?
Yes, replying affidavit. The issues raised in the replying affidavit. That is the affidavit opposing bond. Mr. Muteti will handle the issues of law and the authorities that we have.
So Mr. Njeru is appearing in SEC 25?
26.
Or 26?
26 of 2018. Together with Mr. Muteti and Mr. Mwicigi.
So Mr. Muteti deals with issues of law?
Yes, partially, and Mr. Mwicigi also. Your Honor, in respect to 25 of 2018,
let me finish with 26.
We are most obliged.
I will set timelines. How long will Mr. Njeru take? Yes.
Mr. Njeru should take 15 minutes.
Mr. Muteti.
Mr. Witty and Mr. Muteti would take approximately 25 minutes.
Each or?
No, both of them. And we are ready. It won't take so long. We'll just be expounding on the salient features in the authorities that we have we have filed in court.
To consider consolidating these two cases just on the issue of bail.
Yes.
Yes. Are you opposed?
Yes, we are opposing.
Are you opposed?
It's to what? Sorry. I think
You're arguing together.
that's all right. We have consulted and I think it's okay.
Any counsel who is opposed to that consolidation?
For purposes of bail,
Bail.
it would save time to argue the application together so that different counsel can address your odd issues. The questions are the same. Then I thought, though, that you'd start with us because they'll be responding. Yeah, they can't ask for 30 minutes and they don't know what we are going to say.
Because we are the ones who are applying for bail.
We are usually prepared for the worst, I can say. So we are prepared.
We'll give you the best. And Your Honor, if the record could reflect, we have received the affidavits in number 25 and number 26.
Let me finish with my...
It's okay.
Yes, authorities, yes. Okay. And then I've also given court. Yes.
So for purposes of dealing with bail only, ACC 25 and ACC 26 will be consolidated and be argued as one. The lead file shall be ACC 26 of 2018.
It's very angry, and we are saying don't get angry.
Have you agreed who comes first?
Yes, Your Honor.
Yes.
Yes, Your Honor, can we... I do not know whether the court wants to deal with time allocation. I could start, Your Honor. I will just take about 20 minutes, then I'm sure the council will then take up and proceed and add on to the issues here. Your Honor, just in a sequence, I'll address you briefly on the question of bail. Thereafter, my learned friend, Mr. Asa Nyakundi, will address you. Ken Nyaundi, Migos Ongamba, Gwandugi, and Kurgat. And then myself, Asa Nyakundi.
Yes.
Dr. Nyaundi, Gwandugi,
Yes.
Kurgat, Migos Ongamba, and Mr. Kinyanjui. And of course, Mr. James Singh will also address you. Then I may start, just to
That
save
will,
the court's time.
in that order.
Yes, in that order. Then yes. There may be other additional submissions.
Yes.
Yes, Your Honor, we wish to apply for bail on behalf of the accused persons. The accused persons in files 26 and 25. Your Honor, we have supplied the court with the decision of the High Court in application number 12 of 2018, Rogers Nzioka and 11 others, which, Your Honor, sets out a benchmark of what factors the court should take into account in granting bail. Your Honor, bail is a constitutional right as set out under Article 49(1)(h) of the Constitution, but may be limited where there are compelling reasons not to be released, Your Honor. Your Honor, such compelling reasons would be set out in an affidavit that would define why specific accused persons would not be released on bail. As my learned friends will add, we have this afternoon been served with an affidavit of Walter Oginga Okello, which is filed in court today and which runs to 23 paragraphs with no specific detail or reason advanced against any specific accused person, and that would warrant that accused person the denial of bail, Your Honor. Your Honor will note that the ratio and the analysis of the conditions of grant of bail under 49(1)(h) are set out from pages 13 to 22 of the decision of Judge Hedwig Ongudi in the Rogers Nzioka case. You know, the court will consider the following: the nature of the offense, the character, antecedents, and associations of the accused persons, their record in fulfillment of the obligations under previous grants of bail, and the strength, Your Honor, antecedents, associations, and community ties of the accused persons, the accused person's record in fulfillment of obligations under previous grants of bail, and the strength of evidence of his having committed the offense. Largely, Your Honor, it would be noted that all the accused persons in court have either been employees of, or in case number 25 and number 26, save for the first accused person, who is now the aspiring chair of the Salaries Remuneration Commission, all the other accused persons in file number 26 are managers with the Kenya Power and Lighting Company. They are in service and in the employment of KPLC, a company that is listed and that is in Kenya, and whose domicile is well known to the court and to the prosecution. Your Honor, no material has been supplied to this court through the affidavit of Walter Oginga Okello, Inspector of Police, sworn today, that any of these accused persons has any antecedents, associations, or ties that may characterize or define the said accused person as a flight risk. No record has been supplied to court. Only general statements have been made by the said Inspector of Police of the general possibility that the accused persons may interfere with undisclosed, Your Honor, undisclosed witnesses, Your Honor. Your Honor, the law presumes the accused persons innocent, and they are entitled to bail. The entitlement to bail, Your Honor, is therefore unqualified, as no material has been presented to court beyond the affidavit, which itself has not annexed any material, Your Honor, that shows to the contrary. And we will submit, Your Honor, at this stage that the accused persons, therefore, are entitled to bail. Let me move to the second point, Your Honor. Your Honor, how would the court mitigate the questions that have been set out? Your Honor, the only question that has been set out in the affidavit of Inspector Whitty relating to the accused persons number 2 to number 10 in charge number 26 is at paragraph 13. And the information, Your Honor, is that these accused persons are senior officers and that have access to company-sensitive operation systems and are super users of the management electronic system of the company and may therefore interfere with those systems. Your Honor, that would be a simple point, Your Honor. If that's the only ground, Your Honor, the court can provide conditions that the accused persons do not visit Kenya Power or their place of employment pending the time that the prosecution may say that they require to carry out investigations if the interference relates to the material at Kenya Power or in their offices, Your Honor. Of course, that would raise the other question, Your Honor. A case of such a magnitude, the prosecution would be in court before investigating, before getting electronic evidence from the material at Kenya Power and Lighting Company, Your Honor. That is unbelievable, Your Honor. But moving to the second point, Your Honor. Your Honor, are the accused persons a flight risk? no evidence has been presented in the affidavit of Inspector Okello that any of the accused persons is likely to leave jurisdiction to avoid due process or to escape trial. No character evidence or antecedents have been presented to the court. The other question that Your Honor would qualify your grant of bail as a factor would perhaps be national security. Are there risks national security? The answer is no, Your Honor. No evidence has been presented in the affidavit of Mr. Okello on this question, Your Honor. And this court has had occasion to deal with similar questions on requests of bail by individuals who are even dual citizens, Your Honor. Reasonable restriction is often given as a condition where accused persons are required to deposit their travel documents so that they are within the jurisdiction of the court for trial. The prosecution has not said that the accused persons are unwilling to comply with such a term should it be imposed by the court, Your Honor. Your Honor, the principles of fair trial, the principles of Article 49(1)H, the presumption of innocence and the right to bail, Your Honor, and Article 50, Subarticle 2C and J, require that this court places both the accused persons and the interests of the prosecution in a pedestal for fairness, Your Honor. And this is because, Your Honor, judicial authority shall and must be exercised in accordance with the Constitution. This court is further fortified by the bail and bond policy that guides the orders of this court on bail, Your Honor. We would pray, Your Honor, that the accused persons herein being entitled to bail are prepared to execute bonds in reasonable sums or in a reasonable sum as the court may determine. And, Your Honor, such terms should not be prohibitive and or should not take away with the right hand what the left hand has given, Your Honor. For to do so, Your Honor, would negate the very essence of Article 49(1)H, which, as you're aware, Your Honor, expounds what was previously in Section 123 of the CPC, the right to bail.
There is a provision in the Anti-Corruption Act that Mr. Wame had pointed out the last time that a person with the DCI
fairness
cannot swear
we demand that
in matters
the terms and conditions cut across the spectrum.
Anybody with that?
As at the end of the day, what the court requires, Your Honor, is attendance. We would therefore pray for reasonable bond terms for the first accused, to the 13th accused, and we shall make the other applications for in the two matters that have been deferred at the appropriate time once the court has delivered a ruling. You know, the accused persons are prepared to execute bond as the court will determine. And to abide by any other terms as to restrictions that the court may define in terms of travel, in terms of any report that the court may require, Your Honor. And this court has had the advantage of looking at the Rogers and Nzioka case where the same terms were imposed, Your Honor. Your Honor, on the other questions, Your Honor, I wish to rely on two other decisions. The case of Republic and Moses Kinywa, which is a decision of Judge Lesit, and which involved, yes, I've given the decision, Your Honor. The case of Republic and Moses Kinywa, criminal case number 41 of 2012 by Judge Lesit, and which was also decided after the Constitution of Kenya 2010, and which interprets Article 49(1)H and enjoins the court to consider the circumstances of each case, but to include, Your Honor, of primary concern, the fact that bail is granted to secure the attendance of the accused persons in court when required by the court, and is based on the principle that all accused persons are innocent until proved guilty. Another decision, Your Honor, on the same question, the decision of Hassan Omar and Republic. A decision of Justice Achode, the principal judge, that expounds on the said principles of the grant of bail. We supplied copies to the court, Your Honor. And the judge, in analyzing compelling reasons at paragraph 20 to 22, and in a comparative context, Your Honor, found that the obligation to demonstrate to the court the specifics of factors that would deny the grant of bail lies on the prosecution. That burden has not been discharged in the affidavit sworn by Inspector Walter Oginga Akelo. Your Honor, I rest. My colleagues will add on to my submissions, and I thank you.
I mean, that's great.
Yes. Thank you, Your Honor. I stand to